Have you ever paused to wonder how the highest court in our land, the Supreme Court, actually manages its immense workload and how it, upholds its unshakable authority,
Hmm.
or who exactly stands as the vigilant guardian over every single rupee of your tax money, making sure it's spent wisely and, well, ethically?
It's a crucial question.
Today, we're taking a deep dive into the very foundation of India's constitutional framework. We're pulling back the curtain on Articles 128 right through to 151.
Indeed. And these specific articles are really fascinating because they don't just lay out the Supreme Court's extensive powers and its, let's say, intricate procedures for delivering justice.
Right.
They also establish one of the most critical institutions for democratic accountability,
Right.
the Comptroller and Auditor General of India, a true sentinel of public finance.
Exactly. So our mission today is to kind of cut through the legal jargon and unpack these crucial constitutional provisions.
Yeah.
We'll reveal how they actually shape the day-to-day functioning of justice and governance in India, and maybe more importantly, how they impact you, the citizen, in ways you might not have even considered before.
Mm-hmm.
Think of this as your shortcut to understanding the bedrock of our system, hopefully with some surprising facts and those aha moments that make it all stick.
And we'll delve into the why behind these mechanisms, too, understanding not just what they do, but why they were designed this way, what challenges they were intended to address in a young democracy.
Right, the context.
Exactly, and how they continue to be debated and applied in our complex modern state.
Okay, let's unpack this.
The Supreme Court jurisdiction, powers, and procedure, Articles 128, 147.
Our journey kicks off right at the top, the apex of our judicial system, the Supreme Court. And we're starting with Article 128, which I think perfectly blends practicality with a profound respect for judicial experience.
What's really insightful here, I think, is how Article 128 provides this unique mechanism for the Supreme Court to, well, call up its reserves, so to speak.
Right.
It allows for retired judges to temporarily sit and act. And this ensures that a wealth of judicial wisdom, accumulated over decades, isn't just lost to the system the moment a judge hangs up their robe.
It's like having a strategic bench of seasoned legal heavyweights ready to step in when needed, isn't it?
Precisely.
This article matters because it's a smart, flexible way to manage the judicial workload, maybe address temporary shortages of judges, or even tap into highly specialized expertise without that lengthy and rigorous process of permanent appointments.
Yes.
Imagine a really critical case needing deeply nuanced expertise. This mechanism makes sure that wisdom isn't lost.
Exactly. The core idea is flexibility. Now, the request for a retired judge has to come from the Chief Justice of India, the head of the judiciary.
Okay.
But it requires the president's prior consent. And this isn't just a rubber stamp, it's a crucial constitutional prerequisite. It ensures a check from the executive on such a high-level administrative decision.
That's important.
And what's also interesting is who's eligible. It's not just retired Supreme Court judges. It could be former federal court judges, the SC's predecessor, or even retired high court judges who are technically qualified to sit on the Supreme Court. That was an expansion brought in by the 15th Amendment, actually.
Wow, so it's quite broad in its reach then.
It is.
These individuals are asked to sit and act as a judge of the Supreme Court, which, well, clearly shows the temporary nature of their role, right?
Yeah, temporary.
They get allowances determined by the president, not a fixed salary. But here's the critical part for you, the listener. While they are actively sitting and acting, they possess all the jurisdiction, powers, and privileges of a regular Supreme Court judge.
Absolutely.
Their rulings carry the exact same weight. That ensures seamless judicial functioning.
And this is key, the article makes a crucial distinction. It says they shall not otherwise be deemed to be a judge of that court. So what does that mean? It means they don't count towards the court's overall permanent strength. They're not part of the collegium for appointments, and they don't gain seniority.
Right.
They are there for a specific, often urgent purpose. And importantly, this isn't like conscription. The retired judge's consent is absolutely necessary. It's a voluntary service, tapping into that valuable brain trust of experience.
That distinction is definitely key. This isn't some kind of backdoor way to fill systemic vacancies, is it? It's a flexible tool.
Exactly.
For example, if the Supreme Court is facing a huge backlog in a really complex area, like, intricate environmental disputes or maybe constitutional tax matters,
Very highly specialized.
the Chief Justice could request a retired judge known for their expertise in that exact field. It ensures justice isn't stalled just because of a lack of hands or specific knowledge. And that directly impacts you by making sure critical cases, especially those needing that deep, nuanced expertise, keep moving through the system efficiently. Okay, from adding strength, let's pivot slightly to how the Supreme Court upholds its own dignity and ensures its orders are actually respected. This brings us to Article 129.
What's fascinating here is that Article 129 establishes the Supreme Court as a superior court of record. And, importantly, it explicitly grants it the inherent power to punish for its own contempt.
Inherent power.
Yes. This power is essentially the court's institutional self-defense mechanism. It's fundamental for safeguarding its majesty and ensuring that justice isn't, undermined.
And why this matters is quite profound, isn't it? This power is foundational for upholding the dignity, the authority, and, the very majesty of the Supreme Court.
Absolutely.
It ensures its orders are respected and obeyed, and prevents any deliberate interference with the administration of justice. Being a court of record means its acts and judicial proceedings are recorded for, perpetual memory and testimony.
They have such high evidentiary value that their truthfulness can't be questioned in other courts.
Wow.
And that includes the explicit constitutional power to punish for contempt. We can generally think of contempt in two broad categories.
Okay.
There's civil contempt, which is basically willful disobedience to court orders, judgments, or undertakings. Someone just ignoring what the court clearly said.
Right.
Then there's criminal contempt. This involves acts that scandalize or lower the authority of the court, or prejudice, or interfere with judicial proceedings, or generally obstruct the administration of justice.
So this isn't just some power granted by a regular law passed by Parliament. Article 129 gives it constitutional status.
Precisely.
And while Parliament has enacted the Contempt of Courts Act to define and regulate contempt, that act cannot actually curtail the Supreme Court's inherent constitutional power under Article 129.
That's a key point. The power scope is quite wide. It extends beyond acts committed right there in its physical presence to any act anywhere that undermines its authority. It's important to add, though, that this is a power the court is expected to exercise with extreme caution. Sparingly.
Sparingly.
Yes, sparingly. It has to be carefully balanced against fundamental rights, particularly freedom of speech. Fair criticism of judgments made in good faith is generally not considered contempt.
That's a relief.
But, for example, if a party willfully ignores a clear direction from the Supreme Court in, say, a long-standing property dispute, the other party can file a contempt petition.
Okay.
Or, on the criminal side, if someone were to make widespread, baseless, really scurrilous public allegations against Supreme Court judges with the clear intent to undermine public confidence in the judiciary, that could potentially be criminal contempt.
So this is the court's shield, really. It ensures its decisions carry the weight they need to, and that the whole system of justice runs smoothly and isn't deliberately sabotaged. It's about protecting the entire institution, the rule of law, not just shielding individual judges from any and all criticism.
Well put.
And it directly impacts you, the listener, by ensuring the justice system functions effectively, upholding the sanctity of legal decisions that affect everyone. 2. The court's physical and functional foundations. Now that we've sort of explored how the Supreme Court protects its institutional integrity, let's talk about its physical presence. Article 130 outlines where the court sits and its potential to operate from other locations.
Right. Article 130 establishes Delhi as the primary fixed seat of the Supreme Court. This provides a central, authoritative location.
Makes sense.
But importantly, it also grants flexibility. The court can sit in other places if such a decision is made by the Chief Justice of India, but crucially, with the president's approval.
Okay, so it's not just the CJI's call.
No.
This provision matters because it balances that need for a single, authoritative main seat with the potential for enhancing access to justice, doesn't it?
It does.
By allowing sittings elsewhere, it could potentially cater to regional needs or maybe specific circumstances. And for you, the citizen, this directly impacts your access to the highest court.
Sure.
I mean, is justice only for those who can afford the trip to Delhi? That's a big question.
It's a valid concern. The procedure is that the Chief Justice initiates the idea, reflecting the judiciary's internal administrative needs. But, as we said, it requires the approval of the president. This brings in the executive's consent, often considering the broader administrative and, of course, financial implications. The phrase from time to time suggests it's meant for temporary or need-based arrangements, not necessarily permanent shifts.
What's fascinating here is that this very article, Article 130, fuels a really long-standing and often quite passionate debate.
Oh, yes,
The demand for establishing permanent regional benches of the Supreme Court in different parts of the country.
indeed. Advocates argue, quite compellingly, that regional benches would significantly improve access to justice for people living far away.
The cost in time.
Exactly. Traveling to Delhi can be incredibly costly and time-consuming. They also argue it could reduce the immense burden on the Delhi seat.
Makes sense on the surface.
However, the Supreme Court itself has generally been, let's say, hesitant.
Why is that?
Well, citing concerns about potential fragmentation of judicial thought. They worry it could dilute the court's authority as a single apex institution. And there are logistical challenges in ensuring consistent legal pronouncements across multiple benches.
Fragmentation versus access. That's the tension.
Precisely. It's a fundamental question of balancing practicality and ease of access for the common citizen against the institutional integrity and unity of the highest court. And while this power exists, as you noted, it has been used very, very rarely for temporary sittings outside Delhi. Maybe a few brief sittings in Hyderabad and Srinagar in the past.
So it really highlights that inherent tension, doesn't it, between making justice accessible and maintaining that single, unified judicial voice at the very top. 3. The Supreme Court's core jurisdictions. Okay, from the court's physical location, let's dive into its very reason for being its core jurisdictions. We'll start with Article 131, which details the Supreme Court's original jurisdiction.
Right. Article 131 confers an exclusive and direct jurisdiction on the Supreme Court to hear certain specific types of disputes, particularly those between the constituent units of the Indian Federation, so between states, or between the center and states.
Yeah.
In these specific cases, it acts as a federal court, essentially bypassing all the lower courts. These cases start and end right there.
This jurisdiction sounds absolutely essential for keeping the peace in our federal system, right?
Absolutely. Think about it. If states and the central government couldn't resolve their major disputes in a neutral, authoritative forum, well, disagreements could quickly escalate into political chaos, couldn't they?
Yeah, no legal recourse.
Exactly. Article 131 prevents that.
So it's exclusive, meaning no other court can touch these cases.
Exclusive. The article says to the exclusion of any other court. The parties must be either the government of India and one or more states, or the government of India and some states on one side versus one or more other states on the other, or simply between two or more states.
Okay.
And crucially, the dispute has to involve a question, whether of law or fact, on which the existence or extent of a legal right depends.
A legal right.
Yes. This ensures the dispute is justiciable, something the law can actually resolve, rather than being a purely political disagreement.
So give us an example. If, say, the state of West Bengal challenges a central law, claiming it infringes on its legislative powers under the Constitution.
That's a classic Article 131 case. Goes straight to the Supreme Court.
Or maybe two neighboring states, like Karnataka and Tamil Nadu, have a long-standing dispute over river water sharing, assuming it's not exclusively handled by a specific tribunal.
Or a boundary dispute involving legal rights. Yes. Those are the kinds of big constitutional battles between governments that are heard directly by the Supreme Court.
It really sounds like a cornerstone of India's federal structure then. A crucial dispute resolution mechanism.
It is. And that legal right requirement acts as a critical filter. It keeps the Supreme Court focused on fundamental legal rights and obligations, preventing it from getting bogged down in purely political or administrative tiffs.
So, the Supreme Court acting as the referee for the nation's federal structure.
Exactly. And the outcome of these cases, can directly affect policies that touch your life, depending on how power is shared and exercised.
Okay, moving beyond those direct disputes between governments, Article 132 talks about the Supreme Court's appellate jurisdiction, specifically when it comes to constitutional questions.
Right. Article 132 provides a specific route for appeals to the Supreme Court from any judgment or final order of a high court. But there's a big if.
What's the if?
If the high court certifies that the case involves a substantial question of law as to the interpretation of this Constitution.
Okay. So the high court has to agree it's a big constitutional question first.
Precisely. This makes the Supreme Court the ultimate interpreter of our foundational legal document.
And why this matters is really about consistency, isn't it?
Absolutely. This provision reinforces the Supreme Court's role as the final authority on constitutional interpretation. It ensures uniformity and stability in how our Constitution is understood and applied across the entire country. No conflicting interpretations floating around.
So the appeal can come from any kind of high court case, civil, criminal, whatever.
Yes, any proceeding. The absolute key condition is that high court certification, often granted under Article 134A these days, stating it involves that substantial question of law as to the interpretation of this Constitution. Once that certificate is granted, then any party can appeal to the Supreme Court, specifically arguing that the constitutional question was wrongly decided by the High Court. And final order here is quite broad. It can include even an interim order if deciding it one way would effectively end the whole case.
So the high court acts as a kind of gatekeeper here,
A very important one.
making sure only genuinely significant constitutional interpretation questions reach the top court, preventing a flood of routine appeals.
Exactly. And a question is substantial if it's, say, of general public importance or directly affects the party's rights, isn't easy to answer, or involves debating different viewpoints. And importantly, it shouldn't be something the Supreme Court itself has already definitively settled.
Right. No point relitigating settled law.
No.
So, for instance, if a high court rules in a criminal case and the whole decision hinges on a really novel interpretation of Article 21, the right to life and personal liberty, the losing party could ask for that certificate to appeal.
Yes, ensuring the highest court provides an authoritative interpretation of that fundamental right. This is how our Constitution is continuously defined and redefined. What the Constitution actually means in practice can evolve and be clarified through these appeals. And that directly affects the fundamental rights and the powers of government that impact your life every day.
Now let's turn to Article 133. This one covers the Supreme Court's appellate jurisdiction, but specifically for civil matters.
Right. Article 133 governs appeals to the Supreme Court from high court decisions in civil cases. And the filter here is even stricter, generally, than for constitutional appeals.
Stricter how?
The High Court has to certify two things. First, that the case involves a substantial question of law of general importance.
Okay, general importance.
Yes, meaning it affects the public at large or a significant segment, not just the specific parties involved. And second, the High Court must also certify that this question needs to be decided by the Supreme Court.
Needs to be decided.
Meaning, the High Court thinks the question is so significant or perhaps so unsettled, maybe different high courts disagree, that only an authoritative decision from the apex court will really do.
Got it. So this acts as another crucial filter, right? Making sure the Supreme Court isn't just swamped with every single civil dispute.
Precisely. It lets the court focus its attention on issues that have a significant legal impact or widespread public importance, allowing it to authoritatively shape the civil law of the land. It's really about efficient justice.
That both conditions must be met, general importance and the need for an SC decision.
Both. And even in a civil appeal admitted under this article, if a substantial question of constitutional interpretation also comes up, it can still be argued.
Okay, now here's a crucial point for you, the listener, isn't there? About appeals from a single judge.
Yes, very important practically. Clause 3 of Article 133 states that generally no appeal lies directly to the Supreme Court from a judgment, decree, or final order of a single judge of a high court.
So if a single high court judge dismisses your writ petition in a civil matter, you can't just run straight to the Supreme Court under Article 133.
Typically, no. You must first pursue an intra-court appeal, an appeal within the same high court, usually to a division bench, 2 or more judges, if that option is available under the high court's rules.
Right, exhausting the internal remedies first.
Exactly. And the 30th Amendment back in 1972 was really significant here. It got rid of appeals based just on a monetary value of the dispute.
The old money threshold.
Yes, and replaced it with this much stricter 2-part test focusing on general importance and the need for an SC decision. This dramatically reduced the Supreme Court's workload, allowing it to really concentrate on matters of national legal significance.
So, while it might sound technical, it directly affects how efficiently and strategically the top court operates, shaping the civil law landscape for everyone's benefit. Okay, next up, Article 135. This one acts as a fascinating kind of historical bridge dealing with the jurisdiction of the federal court.
That's right. Article 135 is essentially a transitional provision. It was designed to ensure continuity of jurisdiction when India became a republic.
How so?
It allowed the newly established Supreme Court to exercise any jurisdiction and powers that were vested in the federal court, which was India's highest court before the Constitution came into force under any existing law at that time.
Okay.
This was especially important for matters that weren't specifically covered by the new appeal provisions in Article 133 for civil cases or Article 134 for criminal cases. It filled potential gaps.
So this article was critical because it prevented any kind of, legal black hole.
Exactly. A hiatus or vacuum in appellate jurisdiction during that massive shift from the old colonial legal frameworks to the independent Indian Constitution. It essentially protected the vested rights of litigants whose cases were already underway under the old laws.
Right. Their right to appeal shouldn't just disappear.
Precisely. The article itself says its operation is until Parliament by law otherwise provides, showing that Parliament could update or replace this. The key was that the power had to be exercisable by the federal court immediately before the Constitution commenced, under any existing law, pre-Constitution statutes, rules, etc. Those powers were then vested in the new Supreme Court.
So you called it a constitutional handover clause.
That's a good way to put it.
Without it, many legal proceedings started under older laws might have just been left hanging, with no clear path for appeal in the new system.
Correct. Its main goal was preserving those substantive rights of appeal. While it was incredibly important in the early years, its direct operational relevance has significantly diminished over time as Parliament enacted new comprehensive laws covering appeals.
But it tells us how the new Supreme Court built on the foundations of its predecessor, right? Making sure legal processes for you, the citizen, weren't suddenly cut off during that huge transition to an independent India. And now, for what many consider the Supreme Court's most potent and perhaps most widely used power, Article 136, special leave to appeal.
Ah, yes. Article 136, it confers an extraordinarily wide discretionary and sort of residuary power on the Supreme Court.
Residuary meaning?
Meaning it covers things not specifically mentioned elsewhere. It allows the court to grant special leave to appeal from virtually any judgment, decree, determination, sentence, or order.
Any order.
Any order in any cause or matter passed or made by any court or tribunal in India. It's incredibly broad.
Wow, that sounds huge. It's often called the ultimate safety valve of our judicial system, isn't it?
It is. It allows the Supreme Court to step in truly exceptional circumstances to prevent a substantial injustice, or to correct grave errors, or maybe settle really significant questions of law, even if no other regular appeal route is available under the Constitution or other laws.
It's like the court's ultimate discretionary power to ensure justice is done.
Precisely. Its opening words, notwithstanding anything in this chapter, give it overriding effect. It takes precedence over the other appellate provisions we discussed.
Okay.
And it's a discretionary power. The court may, in its discretion, grant special leave. This is absolutely crucial. Appealing under 136 is not a right for the appellant. The court decides whether to even hear the appeal.
And the scope is massive. Any kind of order, any kind of case, any court or tribunal.
Almost. Civil, criminal, revenue, service matters, environmental cases, you name it. And it extends not just to high courts, but also subordinate courts, statutory tribunals, like, say, the National Green Tribunal, and other quasi-judicial bodies.
Is there any exception?
Yes, there's one very significant exception laid out in Clause 2. This power does not apply to judgments or orders passed by courts or tribunals constituted under any law relating to the armed forces. So no special leave from, say, a court-martial decision.
Okay, that's important to note.
Now, while the power is constitutionally vast, it's meant to be used sparingly, only in exceptional cases. The Supreme Court itself has laid down certain self-imposed restrictions through its judgments over the years.
Like what kind of situations?
Typically, it's invoked when there's been a, gross miscarriage of justice, or a substantial question of law of general public importance is involved that needs settling, or maybe the court or tribunal below acted completely without jurisdiction, or exceeded its jurisdiction, or violated fundamental principles of natural justice.
So if a high court refuses to grant that certificate for appeal under Article 132 or 133,
yes,
the party isn't necessarily stuck. They can still try their luck under Article 136.
They can. They can approach the Supreme Court under 136, arguing that a grave injustice has occurred or an important legal question needs the apex court's resolution.
This really is the most powerful tool the Supreme Court has to step in when all other doors seem closed, the ultimate court of last resort.
But only for truly deserving, exceptional cases. It acts as that final safeguard, ensuring that no grave injustice goes uncorrected anywhere in the country. And it directly affects you by providing that final recourse, that last chance to prevent a serious wrong. 4. Ensuring justice and expanding reach.
Okay, after discussing that immense power under in 36, let's explore something equally fascinating, how the Supreme Court can even review its own decisions. That's Article 137.
Yes, Article 137 grants the Supreme Court the unique and frankly crucial power to review its own judgments or orders. This is a critical self-correction mechanism. It's an acknowledgement, really, that even the highest judicial authority isn't infallible.
Why this matter seems profound. It allows the Supreme Court to correct its own, perhaps, grave errors, prevent potential miscarriages of justice, or maybe address situations where new, absolutely vital information comes to light after the judgment.
Exactly. It ensures that the court's own decisions remain as just and error-free as possible, which is particularly important for a court whose decisions are binding on every other court in the country, as we saw under Article 141.
So how does it work? Does it apply to any judgment?
The power applies to any judgment pronounced or order made by it, so it's broad in that sense. But it's not an unfettered power. It's subject to any laws made by Parliament on the matter, or more commonly, any rules made by the Supreme Court itself under Article 145. Those rules outline the specific limited grounds for review.
And it's definitely not just a chance to re-argue the whole case, right?
Absolutely not. A review is not an appeal in disguise. The court does not rehear the case on its merits. It's exercised only in very limited and specific circumstances.
What are those circumstances, typically?
The Supreme Court rules usually outline them, mirroring the Civil Procedure Code. Generally, it's the discovery of new and important matter or evidence, which, despite due diligence, wasn't known or couldn't be produced earlier.
Okay.
Or a mistake or error that is apparent on the face of the record, meaning it's obvious, self-evident, doesn't require a long, complex argument to spot.
Right, not just something you disagree with.
Exactly. Or, thirdly, any other sufficient reason, which courts have generally interpreted to mean reasons similar or analogous to the first two grounds.
And there's even something beyond review, isn't there? The curative petition.
Yes, that's quite remarkable. Beyond the review power in Article 137, the Supreme Court itself evolved the concept of a curative petition in that landmark 2002 case, Rupa Ashok Hura.
What's that for?
It's an even rarer ultimate remedy, designed to correct gross miscarriages of justice or serious violations of natural justice, even after a review petition has already been dismissed. It truly showcases the court's deep commitment to achieving complete justice no matter what.
So, if a judgment mistakenly relied on a law that had actually been repealed,
That could be an error apparent, grounds for review.
or if a party genuinely discovers crucial documents truly unavailable before, that would have changed the outcome.
Also potentially grounds for review, this whole article ensures judicial integrity, impacting the very legal landscape you live in by allowing for corrections at the highest level.
Okay, moving on. Article 138 looks towards the future, allowing for the enlargement of the Supreme Court's jurisdiction.
Yes, Article 138 provides a flexible mechanism for Parliament to expand the jurisdiction and powers of the Supreme Court beyond what is explicitly laid out in the Constitution itself.
Why does that matter? Why not just amend the Constitution?
Well, it allows the Supreme Court's role to evolve and adapt more easily to new legal needs, complex challenges, and changing governance structures as the nation progresses. Amending the Constitution is a very high bar. This provides flexibility without that cumbersome process for every expansion. It's about future-proofing the highest court, in a way.
How does it work?
Clause 1 allows Parliament, simply by passing a law, to confer further jurisdiction and powers on the Supreme Court concerning any of the matters listed in the Union list, remember. That covers subjects like defense, foreign affairs, banking, communications, etc.
Okay.
Clause 2 offers another route. The Supreme Court can also be given further jurisdiction through a special agreement between the government of India and the government of any state.
An agreement?
Yes, but there's a condition. Parliament must first enact a law specifically providing for the exercise of that agreed-upon jurisdiction by the Supreme Court.
Interesting. So this is quite a forward-looking provision then.
Very much so.
Yeah.
As new sectors emerge, think cybersecurity law, space law, complex AI regulation, maybe.
Right, things the framers couldn't have imagined.
Exactly. And as new regulatory bodies are created under union laws, Parliament can use Article 138 to strategically grant the Supreme Court specialized appellate or supervisory jurisdiction over these new areas.
And Clause 2 promotes cooperation between center and states.
Yes, it fosters cooperative federalism. It allows the union and states to collectively decide that a particular category of, say, interstate dispute or a matter of common interest would be best handled directly by the Supreme Court, subject to Parliament giving the green light via legislation.
So this article ensures the highest court can take on new roles and responsibilities when needed, adapting its scope. This directly impacts the legal landscape you navigate, as the court's authority can expand into new areas of public life. Article 139 then covers the confirmative powers to issue certain writs. This sounds like another potential expansion.
It is, potentially. We know Article 32 already empowers the Supreme Court to issue various writs, habeas corpus, mandamus, prohibition, quo warranto, certiorari, but specifically for the enforcement of fundamental rights.
Right. Article 32 is the big one for fundamental rights.
Correct. Now, Article 139 gives Parliament the power to extend this writ-issuing authority of the Supreme Court to other purposes as well.
Other purposes beyond fundamental rights.
Exactly. Why this matters is that it envisions a potential expansion of the Supreme Court's role. It could potentially act as a court of general superintendents for legal rights beyond just fundamental rights, similar to the broader writ power the high courts already have under Article 226, if Parliament decides that's necessary.
So the power to grant this is solely with Parliament.
Yes. The article says, Parliament may by law confer this power to issue these directions, orders, or the specified 5 writs. The critical phrase distinguishing it from Article 32 is for any purposes other than those mentioned in Clause 2 of Article 32.
Okay, clear distinction, but here's the kicker, isn't it? Has Parliament actually done this?
That's the crucial point. Article 139 is not self-executory. Parliament must actively pass a law to confer this broader power.
And
as of now, Parliament has not enacted any general law under Article 139 to grant such wide writ jurisdiction to the Supreme Court for any other purpose.
So, in practice, the Supreme Court's direct power to issue these writs is still primarily limited to enforcing fundamental rights under Article 32.
That's correct. This highlights a subtle but important practical distinction in your legal recourse. While the Supreme Court is the ultimate guardian of your fundamental rights.
Yes.
For many other legal grievances, maybe enforcing a purely statutory right, the high courts, using their broader power under Article 226 for any other purpose, currently offer a more direct and accessible route through writ jurisdiction.
Okay, to help manage all these cases and ensure consistency, Article 139A allows for the transfer of certain cases. Tell us about that.
Right. Article 139A empowers the Supreme Court to do 2 main things. Transfer cases involving the same or substantially the same questions of law from high courts to itself, or transfer cases from one high court to another high court.
Why is this needed?
Well, this article is vital for ensuring judicial efficiency, for one. It helps avoid conflicting decisions from different high courts on the same important legal questions.
Which would cause chaos.
Exactly. And it's also crucial for guaranteeing that justice is not only done, but seen to be done, especially in sensitive cases where maybe local bias or pressure could be a concern.
Okay, so how does the transfer to the Supreme Court itself work?
Clause 1 covers that. It applies when cases involving the same or substantially the same questions of law are pending either before the Supreme Court and 1 or more high courts, or maybe just before 2 or more high courts.
Right.
The Supreme Court has to be satisfied either acting on its own initiative, sua motu, or on an application by the Attorney General or a party involved, that these common questions are substantial questions of general importance.
Substantial and of general importance again.
Yes. If satisfied, the Supreme Court can then withdraw these cases from the high courts and decide them all itself. Or, flexibly, it can just decide the common legal questions and send the cases back to the original high courts with its ruling for them to dispose of the case accordingly.
Okay. And what about transfers between high courts?
That's Clause 2. It gives the Supreme Court broad discretion. It can transfer any case, appeal, or other proceeding from one high court to another if it deems it expedient so to do for the ends of justice.
Ends of justice. That sounds very broad.
It is. It's incredibly important for situations where fairness or impartiality might genuinely be questioned. Think of a really high-profile criminal trial where there's a credible fear that local sentiment or political pressure could prevent a fair trial. The Supreme Court can use this power to move the case to another high court in a different state.
That's a powerful tool for fairness.
Absolutely. This whole provision, 139A, is invaluable. Imagine multiple challenges to a new central act filed in different high courts. Instead of risking conflicting judgments, the SSC can consolidate them for a single authoritative ruling.
So it's about getting clear, consistent answers to big legal questions and also ensuring you get a fair shot at justice, wherever your case might be, streamlining the process and protecting fairness.
Right, rounding out this section on expanding reach, we have Article 140, which talks about ancillary powers of the Supreme Court. What does that mean? Article 140 essentially empowers Parliament to confer supplemental powers upon the Supreme Court. These aren't new types of jurisdiction, but powers needed to help the court more effectively exercise the jurisdiction it already has under the Constitution.
Why is that necessary? Doesn't the court already have the powers it needs?
Well, it provides crucial flexibility. It ensures that the court's existing jurisdiction isn't hampered by a lack of necessary supporting powers or procedural tools, especially as new complexities arise. It allows the court to adapt without diluting its core constitutional mandate and without needing a constitutional amendment every time a new procedural tool is needed.
So who gives these powers?
Parliament does, by law. The article says Parliament may, by law, make provision for conferring such supplemental powers. These are auxiliary, additional powers designed to aid the exercise of existing jurisdiction.
Not expand the core jurisdiction itself.
Exactly. That's the key distinction from, say, Article 138, which can enlarge jurisdiction. Article 140 is more about the tools. For example, powers related to complex investigations, securing the attendance of reluctant witnesses, enforcing its orders more effectively in tricky situations, or managing complex evidence.
And these powers have to be consistent with the Constitution.
Absolutely. The article explicitly says such powers must not be inconsistent with any of the provisions of this Constitution. They have to fit within the overall framework.
Can you give an example?
Sure. Imagine Parliament enacts a law setting up a special investigative agency, or maybe a panel of technical experts, specifically to assist the Supreme Court in conducting complex fact-finding, say, a big environmental case under its original jurisdiction.
Yeah.
That would supplement the court's ability to gather and assess the facts effectively.
Okay, I see.
Think of it as providing the Supreme Court with all the necessary equipment and logistical support to do its job optimally, making sure the engine of justice has all its parts working perfectly so your cases are handled effectively. V, the apex court's authority and enforcement.
Okay, now we come to Article 141. This sounds like a real cornerstone of our legal system, dealing with how the Supreme Court's pronouncements affect all the other courts.
It absolutely is a cornerstone. Article 141 constitutionally enshrines the doctrine of precedent, or stare decisis, as lawyers call it, in India.
Stare decisis, stand by things decided.
Exactly. It unequivocally declares that the law pronounced by the Supreme Court shall be binding on all other courts within the territory of India. Full stop.
Wow. So this is the bedrock of legal uniformity, certainty, and predictability across the country.
Precisely. It establishes the Supreme Court as the supreme legal authority. It ensures that its interpretations of law are followed consistently by every single other judicial body. When the Supreme Court speaks on a point of law, its word becomes the law for the entire nation.
And what exactly counts as the law declared? Is it everything the judges say?
Good question. It primarily refers to the ratio decidendi of its judgments.
Ratio decidendi.
That's the essential legal principle or the core reasoning upon which the decision is actually based. It does not strictly include obiter dicta.
Obiter dicta,
Yeah.
passing comments.
Yes, passing observations or remarks made by the judges that weren't essential for reaching the final decision. Though, obiter dicta from the Supreme Court can still have significant persuasive value for lower courts.
Okay. And this shall be binding applies to all courts.
Yes, every judicial body in India, all high courts, subordinate courts, tribunals that exercise judicial functions, the binding effect is nationwide.
So if the Supreme Court, in a landmark judgment, clarifies the scope of, say, a fundamental right, all high courts and lower courts are then absolutely bound to apply that interpretation in every similar case that comes before them.
They are. It ensures consistency and fairness for you, the citizen, no matter which court you happen to be in. It shapes the entire legal framework governing life in India.
Now, here's an interesting question. Is the Supreme Court itself bound by its own previous decisions?
That's a crucial nuance. Well, Article 141 makes the SE's decisions binding on all other courts. The Supreme Court itself is not absolutely bound by its own precedents.
Really?
Yes. In appropriate cases, particularly when sitting in larger benches, it can reconsider and even overrule its earlier judgments if it finds them to be clearly erroneous or perhaps outdated or maybe even detrimental to the public interest in light of changed circumstances.
So the law can evolve at the highest level, too.
Exactly. This allows for the progressive development of law and prevents the legal system from becoming rigid or stuck with past errors.
Okay, next up, Article 142. You mentioned this earlier, an incredibly powerful provision focusing on the Supreme Court's ability to deliver complete justice. Let's unpack that.
Right. Article 142 is singularly powerful and, frankly, quite unique to our Constitution. It's often called the Complete Justice Clause.
How does it do?
It grants the Supreme Court plenary, meaning full and complete powers to pass any decree or order that it deems necessary for doing complete justice in any case or matter that's pending before it.
Any order necessary for complete justice. That sounds incredibly broad.
It is, and importantly, any order made under Article 142 is enforceable throughout the entire territory of India.
Wow. So this is like the ultimate constitutional safety net for justice.
That's a great way to put it. It allows the Supreme Court, when necessary, to transcend procedural technicalities, maybe fill in gaps in the existing law, or even bypass rigid statutory provisions if they stand in the way of achieving true and equitable justice in complex or perhaps unprecedented situations. It's really the court's innovative and remedial heart.
Ensuring justice isn't just a theoretical concept, but a tangible reality.
Exactly. Now, while the power is extraordinary and discretionary, meant to be used with great caution, the court has also clarified its limits. It's generally not meant to be used to simply override or make orders that are directly contrary to clear statutory provisions or substantive law.
So it's not a blank check to ignore laws.
No, it's primarily seen as a remedial power, to fill gaps, to mold the relief granted to fit the specific situation, or to overcome procedural hurdles where the existing law is perhaps silent or just inadequate to address a particular injustice.
Can you give an example of when it's been used?
Sure. The famous Bhopal gas tragedy case, Union Carbide, is a key example. The court invoked Article 142 to uphold a settlement for the victims, arguing it was necessary to do complete justice and provide relief, even though it involved quashing certain related criminal proceedings, a controversial but illustrative use of the power.
So it's where the court can be truly innovative and responsive.
Yes, especially in situations that legislation might not have fully anticipated. Think about a major public interest litigation concerning severe environmental damage where existing laws aren't providing quick enough or effective enough remedies.
Okay.
The Supreme Court might use Article 142 to issue comprehensive, time-bound directions directly to government agencies, maybe even setting up monitoring committees to ensure concrete action is taken.
This really goes to the heart of the Supreme Court's mission then, not just applying the law as written, but ensuring complete justice.
Absolutely. It allows the court to adapt and respond to unique situations, impacting monumental cases and sometimes even individual lives, making our legal system truly dynamic for you.
Okay, Article 143 gives the president a unique power, the power to consult the Supreme Court.
Yes, Article 143 confers a unique advisory jurisdiction upon the Supreme Court. It allows the President of India, acting on the advice of the government, of course, to consult the court on certain questions of law or fact that are deemed to be of public importance, or on specific disputes that arose before the Constitution came into force.
Why would the president need to consult the court like this? Why not wait for a case?
Well, this provision allows the executive branch to get an authoritative, though importantly non-binding, legal opinion from the highest court on complex or significant constitutional matters before taking action.
Ah, so it's like preventive legal guidance.
Exactly. It helps the government make informed, constitutionally sound decisions, potentially avoiding legal pitfalls down the road. It can help resolve constitutional ambiguities without needing formal adversarial litigation, which can take years.
How does it work?
Under Clause 1, if it appears to the president that a question of law or fact has arisen or is likely to arise, and it's of such public importance that getting the SC's opinion is expedient, the president may refer the question. The court then may report its opinion.
May report.
Sure.
So the court can refuse.
The use of may suggests the court technically has discretion to decline answering under Clause 1, perhaps if the question is seen as purely political, too hypothetical, or vague, though in practice it rarely refuses references under Clause 1.
Okay. Is there another part?
Yes, Clause 2 deals specifically with those pre-Constitution disputes involving treaties or agreements that are excluded from the court's regular original jurisdiction under Article 131's proviso. For these, the president may refer them, and the court shall report its opinion. The use of shall here suggests a stronger obligation on the court to provide an opinion on these specific historical disputes.
So the opinion they give, is it binding? Does it become law-like under Article 141?
No, absolutely not. The opinion rendered under Article 143 is strictly advisory. It doesn't constitute a judicial judgment, nor is it law declared under Article 141.
But it must carry weight.
Immense persuasive weight. It's generally respected by all concerned. For example, the reference in the Kerala Education Bill, 1957, sought the court's opinion on minority rights and proposed legislation, and the opinion significantly guided subsequent policy.
So this shows the Supreme Court acting almost like a wise counsel to the state, not just a judge after the fact.
That's a good analogy. It's a unique mechanism for preventive legal guidance, helping the government make informed decisions on matters affecting the entire nation, and thus, indirectly, you.
Right, so the court makes these pronouncements, gives opinions, but how do we ensure they're actually put into practice? Article 144 seems key here, outlining a clear duty for all civil and judicial authorities.
Yes, Article 144 imposes a clear, mandatory constitutional duty on all civil and judicial authorities throughout the territory India to actively assist and cooperate with the Supreme Court.
This sounds absolutely fundamental. Without this, the court's orders could just be paper tigers.
Exactly. This article is crucial for the effectiveness and enforceability of the Supreme Court's judgments, decrees, and orders. Without the active cooperation of the executive branch and all other judicial bodies, the highest court's pronouncements will risk remaining just words on paper, undermining the very rule of law. It provides the muscle behind the court's decisions.
Who exactly does all authorities, civil and judicial, cover?
It's incredibly broad. Civil authorities includes literally every level of the executive government, from the highest offices in Delhi down to the local police officer, the district magistrate, administrative officers, all government departments.
Everyone.
Everyone. And judicial authorities covers all other courts and tribunals subordinate to the Supreme Court within India, high courts, district courts, specialized tribunals. The duty is clear. They shall act in aid of the Supreme Court.
Shall act in aid sounds like a positive obligation, not just don't obstruct.
It is a mandatory positive obligation to assist, facilitate, and ensure compliance with the Supreme Court's directives.
So this provision is crucial for turning the court's legal decisions into tangible reality on the ground.
Absolutely. It effectively makes every arm of the state an enforcement agency for the apex court when needed, and it unequivocally reinforces the hierarchical structure of the judiciary and the constitutional supremacy of the Supreme Court's decisions.
What happens if an authority doesn't comply?
Failure by any civil or judicial authority to act in aid of the Supreme Court could lead to very severe consequences, including contempt of court proceedings, which carry potential penal implications.
Give you an example.
Yeah. If the Supreme Court issues a landmark judgment directing a state government to, say, formulate and implement a new policy for cleaning up a river within a specific time frame, under Article 144, all relevant executive authorities in that state are constitutionally bound to take the necessary steps to comply with and execute those directions. Or if the SC orders a lower court to transfer case records immediately, that court must comply promptly.
So when the SEC issues an order, it essentially has the entire machinery of the state and judiciary behind it to ensure compliance.
That's the constitutional mandate. It directly affects how laws and policies are put into practice in your daily life and guarantees the rule of law has teeth.
Okay, now let's look a bit more inwards at the court's own internal workings. Article 145 deals with its rulemaking power. How does that work?
Article 145 is crucial for the Supreme Court's administrative and procedural autonomy. It empowers the court to make its own rules for regulating its practice and procedure.
So the court makes its own rules.
Yes, but with some checks. The rules need the approval of the president, and they are always subject to the provisions of any law made by Parliament. But fundamentally, it allows the court to manage its own house. It also lays down some critical mandatory procedural aspects, like the minimum number of judges needed for constitutional cases.
Why does this matter? Why is this internal autonomy important?
It's vital for efficiency and maintaining high judicial standards. It ensures the Supreme Court can effectively manage its own internal proceedings, ensure transparency, and importantly, dedicate appropriate judicial strength to matters of national constitutional significance without external interference in its day-to-day processes.
So what kind of things do these rules cover?
Clause 1 lists several areas. It includes rules about who can practice before the court, advocates, the procedure for hearing appeals and other matters, like filing deadlines, proceedings for enforcing fundamental rights, dealing with transfer cases under 139A, and very importantly, the conditions and procedure for review of its own judgments under Article 137. It also covers costs, fees, bail, stay of proceedings, etc.
You mentioned a mandatory minimum number of judges.
Yes, that's in Clause 3, and it's hugely significant. It mandates a minimum bench strength of 5 judges for 2 specific high-stakes purposes.
Utah.
First, deciding any case involving a substantial question of law as to the interpretation of this Constitution. Second, hearing any reference from the President under Article 143, the advisory jurisdiction we discussed.
5 judges. A Constitution bench.
Exactly. This ensures that matters of profound constitutional interpretation, the very foundation of our nation's laws, are deliberated and decided by a sufficiently large and senior bench. It lends immense gravitas and authority to such rulings.
What if a smaller bench runs into a constitutional question?
Good point. The proviso to Clause 3 covers that. If a smaller bench, say 2 or 3 judges, hearing a regular appeal, realizes that deciding the case requires resolving a substantial constitutional question, they must refer that specific question for opinion to a Constitution bench of at least 5 judges.
Ensures consistency. And what about transparency?
Clause 4 mandates transparency. No judgment shall be delivered by the Supreme Court save in open court, and advisory opinions under 143 must also be delivered in open court. No secret judgments.
That's crucial for public confidence. And what about disagreements among judges?
Clause 5 addresses that. Judgments and opinions require the concurrence of a majority of the judges present on the bench. But, importantly, it explicitly allows any judge who does not concur to deliver a dissenting judgment or opinion.
Dissents are allowed, even encouraged.
Allowed and constitutionally protected, and these dissents are incredibly valuable. They're not just records of disagreement. They often articulate alternative legal perspectives, highlight potential issues with the majority view, and sometimes, years later, form the intellectual basis for overruling or modifying precedents. They really enrich our legal discourse.
So Article 145 is really about the how of the Supreme Court's daily functioning, guaranteeing transparency, ensuring big constitutional issues get the weight they deserve, and allowing for robust debate within the judiciary itself, all shaping the process of justice you experience. And to protect its independence right down to its administration, Article 146 covers the officers, the servants, and crucially, the expenses of the Supreme Court.
Yes, Article 146 is another critical piece ensuring the administrative independence of the Supreme Court, which underpins its overall judicial independence.
How does it do that?
It vests control over the appointments and service conditions of the court's own staff, largely in the Chief Justice of India. And perhaps most importantly, it makes the court's administrative expenses a direct charge on the Consolidated Fund of India.
Why is that administrative independence so crucial?
Think about it. If the court couldn't control its own staff, or if its budget was subject to the whims of the government of the day through annual votes?
Could be pressured?
Exactly. This administrative autonomy allows the court to function without undue executive or legislative interference in its day-to-day operations. It ensures it has the support it needs to do its judicial work independently.
So the Chief Justice handles staff appointments.
Yes, the CJI or another judge or officer directed by the CJI makes appointments of officers and servants. There's a proviso allowing the president to require consultation with the Union Public Service Commission, UPSC, for certain external appointments, adding a layer of check.
And their service conditions.
Also prescribed by rules made by the CJI, or their delegate, though these rules are subject to any laws Parliament might make. And importantly, rules relating to salaries, allowances, leave, or pensions require the approval of the president. This provides executive oversight specifically on the financial implications for the staff.
Okay, checks and balances there too. But you said the real clincher for financial independence is Clause 3.
Yes. All administrative expenses of the Supreme Court, including all salaries, allowances, pensions for its staff, shall be charged upon the Consolidated Fund of India.
Charged upon meaning.
Meaning these expenses are not subject to the annual vote of Parliament. They're essentially guaranteed funding. Parliament discusses them, but doesn't vote on them like other departmental budgets.
Ah, that's vital. It prevents the budget being used as leverage.
Precisely. It prevents either the executive or the legislature from using financial strings to influence the court's functioning. This directly protects the impartiality and effectiveness of your justice system by ensuring the court has the resources it needs.
So an independent judiciary needs independent administration and guaranteed funding.
Absolutely. A competent, dedicated, and independently managed administrative staff with secure funding is indispensable for the Supreme Court to effectively discharge its vast and complex judicial responsibilities without being beholden to other branches.
Okay, finally for the Supreme Court section. Article 147 provides a specific rule for interpretation. Sounds a bit technical.
It is a bit technical, but it served a very important historical purpose. Article 147 provides a specific rule of construction or interpretation for understanding the phrase substantial question of law as to the interpretation of this Constitution, a phrase we saw used in articles like 132 and 145(3).
Okay, what does Article 147 do to that phrase?
It expands its meaning. It says that wherever that phrase appears in the chapters dealing with the Supreme Court and the high courts, it should be understood as including similar substantial questions of law concerning key constitutional laws.
Pre-constitutional laws, like
Yeah. Specifically, the Government of India Act, 1935, and any amendments to it, any orders in council made under that act, the Indian Independence Act, 1947, and any orders made under that act.
Why was this needed? Those acts aren't in force anymore.
True, but this article was vital in the early years of the Republic. It acted as a legal bridge. Many rights, liabilities, and legal frameworks still being dealt with by the courts had their origins in these pre-Constitution laws. Article 147 ensured legal continuity and clarity by treating major interpretive questions about these foundational historical documents with the same gravity as interpreting the new Constitution itself.
How did it ensure that gravity?
By bringing them under the umbrella of constitutional questions, it meant, for instance, that such questions would require hearing by a Constitution bench, 5 or more judges, under Article 145(3). It ensured these important historical legal questions received the highest level of judicial scrutiny.
So it ensured authoritative interpretation of those old foundational documents.
Exactly. While its primary force was strongest in the early decades after independence, questions relating to the interpretation of these historical enactments can still occasionally arise today, perhaps in complex property disputes or cases dealing with the historical evolution of certain legal principles.
So it's a constitutional nod to history.
You could say that. Ensuring that even today, the Supreme Court can authoritatively interpret the old legal maps that guided India's journey. It impacts cases with deep historical roots and reminds us that our present legal system didn't just appear from nowhere. It stands on the shoulders of these earlier foundational texts.
Wow. So that was a truly expansive exploration of the Supreme Court's towers. I mean, everything from its ability to call on retired judges, its power to review its own decisions, its unparalleled authority for complete justice under 142, and its critical administrative and financial independence. It really is a colossal institution, defining our legal landscape and shaping the very idea of justice in India.
Indeed, a complex and powerful institution. But as you said earlier, the story of constitutional accountability doesn't end with the judiciary.
No, it doesn't.
It moves to another equally vital, though perhaps often less visible, pillar, the one that guards the very financial health of our nation and ensures every single rupee of public money is accounted for.
Right. Here's where it gets really interesting, moving from justice to finance.
The guardian of the public purse, the CAG, Articles 148 to 151. 6. The Comptroller and Auditor General of India, CAG.
Let's turn our attention now to, as you said, maybe an unsung hero of our financial system.
Right.
The Comptroller and Auditor General of India. The CAG, Article 148, lays the groundwork for this incredibly important office.
What's truly foundational here, I think, is that Article 148 establishes the office of the CAG not just as another government department, but as an independent constitutional authority.
Independent is the key word.
Absolutely. Every detail in this article, from appointment and removal to conditions of service, even restrictions after leaving office, is meticulously designed to ensure the CAG's complete independence, particularly from the executive branch whose spending they will audit.
And why this matters cannot be overstated, can it? The CAG is often called the guardian of the public purse.
It is.
This office is absolutely critical for ensuring financial accountability and transparency in how the government operates. It audits how your tax money is actually spent. It's there to help prevent waste, inefficiency, and yes, corruption.
Think about it. Without an independent auditor, the government would essentially be auditing itself.
Which doesn't exactly inspire confidence.
Really?
Yeah.
So Clause 1 makes the office mandatory. There shall be a Comptroller and Auditor General of India. The appointment is high level, by the President, by warrant under his hand and seal. But the removal process is incredibly stringent.
How stringent?
The CAG can only be removed from office in like manner and on the like grounds as a judge of the Supreme Court.
Wow, so like impeachment.
Essentially, yes. It requires an address by Parliament supported by special majorities, only on grounds of proven misbehavior or incapacity. This provides incredibly strong security of tenure, shielding them from political pressure if their audits uncover uncomfortable truths.
So they're definitely not just any government official. Their salary and service conditions are set by Parliament by law, but there's that vital protection, right?
Yes, the proviso to Clause 3. Neither the CAG's salary nor their rights regarding leave, pension, or retirement age shall be varied to his disadvantage after his appointment.
No cutting their pay if the government doesn't like their report.
Exactly. It shields them from financial coercion. And then there's Clause 4, which ensures impartiality looking forward.
What does that do?
After ceasing to hold office, the CAG shall not be eligible for further office either under the government of India or under the government of any state.
No post-retirement jobs from the government.
None. This is a powerful provision. It eliminates any potential temptation or even the appearance of temptation. The idea that maybe a less critical audit now might lead to a nice governorship or commission chairmanship later. It prevents any quid pro quo.
That's a strong safeguard.
And finally, their administrative expenses. The budget for their entire office, staff salaries, everything are, like the Supreme Court's, charged upon the Consolidated Fund of India. Again, not subject to the annual vote.
Guaranteed funding.
Guaranteed funding. All these provisions together create, as you said earlier about the court, an institutional fortress of independence around the CAG.
It's no wonder Dr. B.R. Ambedkar considered the CAG possibly the most important officer in the Constitution.
He did. He saw the CAG as the crucial check, ensuring that money voted by Parliament was spent as intended, not exceeded or diverted.
Now, the title is Comptroller and Auditor General. Does the CAG actually control spending before it happens?
That's a good point. While the title includes Comptroller, which implies pre-expenditure control, that aspect isn't as fully developed in India as, say, in the UK. In India, the CAG primarily functions as an Auditor General, conducting audits after the money has been spent, though they do have a specific role in certifying the net proceeds of taxes under Article 279.
But their audit reports are crucial for Parliament's oversight.
Absolutely. Those detailed reports form the essential basis for scrutiny by parliamentary committees, especially the Public Accounts Committee. The CAG famously acts as a friend, philosopher, and guide to the PAG, providing expert analysis and assistance.
So this is the ultimate watchdog for your money. The CAG's independence means there's a powerful, unbiased eye scrutinizing how the government uses public funds, protecting against waste, ensuring accountability, and ultimately impacting the integrity of public finance and building trust in how your taxes are managed.
Okay, so now we know who the CAG is and how independent they are. Let's explore their actual duties and powers. That's Article 149, right?
Correct. Article 149 basically says that the specific duties and powers of the CAG are to be laid down by Parliament through law.
So the Constitution sets up the office, but Parliament defines the job description. Essentially, yes. It also had an interim provision saying that until Parliament made such a law, the CAG would continue with the duties and powers the Auditor General of India had just before the Constitution began.
Why does this matter? Why give Parliament this power?
It provides flexibility and ensures relevance. It allows Parliament to define and adapt the CAG's role and responsibilities over time. It ensures the audit function remains comprehensive and effective, meeting the evolving needs of financial oversight in a dynamic economy. Things change, new types of government spending emerge, so the audit scope needs to adapt.
Makes sense. So Parliament did define these duties.
Yes, the primary authority rests with Parliament to be done by or under any law, and the scope covers the accounts of the union government, the state governments, and this is critical, and of any other authority or body.
Any other authority or body? That sounds potentially very broad.
It is. And Parliament exercised this power by enacting the Comptroller and Auditor General's Duties, Powers, and Conditions of Service Act, 1971, often called the CAG's DPC Act. This act now comprehensively details the CAG's extensive functions.
So what are the key functions under this act? What does the CAG actually audit?
Oh, it's vast. They audit all expenditure from the Consolidated Fund of India, each state, and union territories with legislatures. They audit all transactions related to contingency funds and public accounts. They audit trading, manufacturing, profit and loss accounts kept by government departments. Crucially, they audit the accounts of bodies and authorities that are substantially financed by grants or loans from the government.
Substantially financed.
Right? They also audit government companies and certain corporations according to specific laws, and they have that role of certifying net tax proceeds we mentioned. Finally, they submit their audit reports to the president or governor to be laid before the legislature as Article 151 mandates.
And you mentioned earlier it's not just checking the sums.
Absolutely not. The CAG's audit goes far beyond mere financial compliance, just ticking boxes against rules. It includes propriety audit examining the wisdom, faithfulness, and economy of expenditure.
Right.
Basically asking, was this spending sensible? Was it necessary? Was it done without extravagance?
Okay.
And it includes performance audit. This evaluates the efficiency and effectiveness of government programs and schemes. Did the spending actually achieve its intended results? Did it deliver value for the taxpayers' money? This is hugely important for accountability.
Performance audits sound crucial. And that phrase, other authority or body, how far does that reach?
That phrase is absolutely key to the CAG's modern relevance and reach. It allows the audit scope, if enabled by law or specific agreements, to extend to various public sector undertakings, PSUs, autonomous bodies funded by the government, and even, controversially sometimes, to private entities that receive significant public funding or utilize public resources.
Private entities, too.
Yes, where public money or resources are significantly involved. Remember that Supreme Court case, Association of Unified Telecom Service Providers. The court upheld the CAG's power to audit the accounts of private telecom companies, but specifically to the extent needed to verify the revenue share they owed the government under their license agreements. It showed the potential reach when public resources are in play.
So Article 149 essentially gives the CAG the legislative backing, the teeth, to dig into practically anywhere significant public money is spent, or even where private entities are benefiting substantially from public resources.
That's the idea. To ensure a holistic check on government spending and performance, which directly impacts how efficiently and transparently public services and projects are delivered to you.
Right. Now, to make all these audits even possible, the accounts themselves need to be kept properly. Article 150 addresses the form in which government accounts are kept.
Yes. Article 150 dictates that the accounts of both the union and the state governments must be maintained in a form prescribed by the president. But, and here's the crucial twist, the president prescribes this form specifically on the advice of the Comptroller and Auditor General of India.
So the CAG advises on the format.
Yes, and on the advice of is a strong phrase, suggesting the president is generally expected to accept the CAG's expert recommendation on this technical matter.
Why does this seemingly technical article matter so much? Just a format, right?
It's fundamental for effective financial oversight. Think about it. For any meaningful comparison between departments or states, for consolidating accounts, for analyzing government finances, all essential for budgeting, economic policy making, and of course auditing, you need standardized, clear, consistent accounting forms.
Otherwise, you're comparing apples and oranges.
Exactly. Article 150 guarantees this standardization. And the CAG, being the primary audit authority with deep expertise in public finance and accounting, is uniquely positioned to advise on the most appropriate, transparent, and comprehensive form for these accounts. That phrase, on the advice of, gives the CAG a powerful voice in setting these crucial accounting standards. It replaced earlier, weaker phrases like after consultation with.
Interesting. Now, I heard something about the CAG no longer keeping the accounts for the union government.
That's correct. A significant change happened back in 1976, specifically at the union level. The CAG was relieved of the responsibility for compiling the union government's accounts. That function was departmentalized, given to the respective ministries themselves.
So the ministries keep their own books now.
At the union level, yes. But, and this is vital, the CAG retained the power to prescribe the form in which those accounts must be kept under Article 150, and, crucially, retain the power to audit those accounts.
Separation of powers almost. Accountant versus auditor.
Precisely. This move was seen as strengthening the CAG's independence as an auditor by separating it from the role of being the government's accountant, while still ensuring the accounts were kept in a way suitable for audit. Now, in most states, the CAG often continues to both compile and audit the accounts, though that can vary.
So this technical article ensures the government's financial books are kept in a way that actually makes sense, is transparent, and allows for comparison.
Correct. Which makes it much easier for the CAG to track every rupee, hold agencies accountable, and ultimately for you to understand where your money is going and how effectively it's being managed. It fosters greater public trust.
Okay, finally, to close the loop on this whole accountability chain, we have Article 151. This deals with the audit reports themselves. What happens to them?
Article 151 mandates the crucial final step. It requires the CAG's audit reports the findings from all those audits we discussed on union accounts to be submitted to the president, and reports on state accounts must be submitted to the respective governor.
Okay, submitted to the head of the executive. Then what?
Then, the president or the governor is constitutionally obliged. The article uses the word shall to cause them to be laid before the respective legislature. So union reports go before both houses of parliament, and state reports go before the state legislature.
So the reports must go to the elected representatives.
I must. This article is the final essential link in the chain of financial accountability. It ensures that the findings of the Independent Audit Authority, the CAG, are brought directly to the notice of the people's elected representatives.
Why is that so important?
Because it enables the legislature, parliament, or the state assembly to actually scrutinize the executive's financial performance. It allows them to hold the government accountable for how it used public funds. It turns the audit findings into a tool for democratic oversight.
Without these reports, the legislature would be flying blind on spending.
Largely, yes. These reports typically highlight financial irregularities, point out inefficiencies, flag wasteful expenditure, and note non-compliance with financial rules. They are potent instruments for oversight. The language "shall cause them to be laid" imposes a clear constitutional duty. Any undue delay in tabling these reports is a serious matter, as it obstructs legislative accountability.
And once the reports are tabled in Parliament or the state legislature, what happens then?
That's where those specialized committees come in, primarily the Public Accounts Committee, PA, and, for public enterprises, the Committee on Public Undertakings, KPU. These cross-party committees take up the CAG reports for detailed examination.
And the CAG helps them.
Yes, the CAG famously acts as that friend, philosopher, and guide to these committees. The CAG's office provides expert assistance, helps them understand the complexities, and often attends committee meetings to clarify findings when officials from the audited departments are examined.
So the committee digs deeper based on the CAG report.
Exactly. They scrutinize the audit findings, question government officials, and then submit their own report with observations and recommendations back to the legislature. This process can lead to corrective actions, system improvements, policy changes, and sometimes even disciplinary proceedings.
So this entire process, independent audit, mandatory reporting to the legislature, committee scrutiny, it's all about public accountability for public money.
Absolutely. It's the moment of truth for government spending. The reports reveal what worked, what didn't, where money might have been wasted, and where improvements are desperately needed. It's the critical mechanism that empowers your elected representatives to hold the government accountable for its financial decisions, and that directly impacts public policy and the efficiency of the public services you receive.
What a journey that was, through the constitutional bedrock of our nation. I mean, from the Supreme Court's incredibly multifaceted powers ensuring justice is served, its authority upheld right through to the relentless vigilance of the Comptroller and Auditor General over every single penny of public expenditure. These articles, 128 to 151, they really are the unsung heroes of our democracy, aren't they?
They truly are. They're not just dry text. They are living instruments, constantly shaping how justice is administered and how financial accountability is enforced in India today. They really reflect the profound wisdom of the Constitution's framers in creating this robust system of checks and balances. And they continue to evolve through interpretation and application, adapting to modern challenges.
And as we've heard throughout this discussion, they directly impact your life. From the integrity and power of the courts you might rely on to the responsible and transparent management of the taxes you pay, the architects clearly envisioned a system where power is checked and balances are maintained at every level. But we also touched on some ongoing debates, didn't we? Like the one around regional benches for the Supreme Court, that whole tension between access to justice versus institutional unity,
A very real tension.
and the evolving scope of the CAG's audit in our increasingly complex economy, especially with more public funds flowing through private partnerships and entities.
Yes. How far should that reach extend?
Exactly.
Sure.
So maybe a final thought for you, our listener, to mull over. What do you think is the next frontier for ensuring justice and accountability in India? Should the Supreme Court perhaps decentralize more to become truly accessible, even if it risks some fragmentation? Or is its centralized authority too precious to dilute?
And on the financial side?
Yeah, as public services get more complex and involve private players, how far should the CAG's audit really go to remain the effective guardian of the public purse? Where is that line between necessary oversight and perhaps overreach into private operations funded partly by public money?
These are profound questions with no easy answers. They will undoubtedly continue to shape our constitutional discourse and the effectiveness of our governance for, well, generations to come.
Food for thought indeed. Thank you so much for joining us on this deep dive. Until next time, stay curious, stay informed. This has been The Deep Dive.